Let's talk about freedom of expression in relation to defamation and criticism of official conduct. For this part, I do not intend to discuss the matter of the specific provisions in the revised penal code or other statutes, but I am more concerned on its implications to this freedom of expression. Article 353 of the revised penal code says that libel suit or libel is a public and malicious imputation of a crime or of a vice or defect, real or imaginary, or any act, omission, condition, status, or circumstance tending to cause the dishonor, discredit, or contempt of a natural or juridical person or blacken the memory of one who is dead. The elements of libel may be better discussed in your criminal law courses. But on the matter of freedom of expression and criticism of official conduct, it has been held and repeated several times in jurisprudence that a public officer should not be too onion skinned or too thin skinned, should not easily be offended or reactive to criticisms involving his official conduct. When a public officer, especially those who are elected, come into office, it is understood that a public officer opens himself to public criticism for his official conduct, at least for his official conduct, because democracy thrives on the vigilance of the public to the wrong committed by public officers, especially those who are elected, because they owe the electorate their loyalty, their obedience to law, and their duty. No? But this expectation of public officers do not apply to matters which are not relevant to their official conduct. The doctrine, nevertheless, would only apply if the defamatory statement was uttered in connection with the public officer's duty. So, the private affairs of a public officer is not of a public's concern or business. The difficulty is on the demarcation on when public interest begins and when it stops. Because, for instance, the lifestyle of a public servant is a matter of a public concern, the lifestyle of his family. So if a public servant chooses to live his private life with all luxury in violation of the expectation of them living modest lives according to civil service law, and when the expenditures are more than their earnings, despite living their lives in private and not being part of their official conduct of their duties, their private life may be subject of public criticism, specifically on the matter involving their um, assets, and of course liabilities or net worth, which are disclosed. And if your income declared is not consistent with your lifestyle, though lived in private, um, it may be subject of public criticism. Um, According to the case of the Leon versus People, there lies a thin line between criticism and outright defamation. When one makes commentaries about the other's performance of official duties, the criticism is considered constructive, then aimed for the betterment of her service to the public. It is thus a continuing duty on the part of the public officer to make room for improvement on the basis of this constructive criticism, in such as it is imperative on the part of the general public to make the necessary commentaries about should they see any lapse on the part of the public officer. So the public life of the public officer, the public service life of the public officer is always open to criticism. Um, the matter of freedom of expression relative to um, this uh, law on libel um, and criticism of official conduct relates to, of course, freedom of the press. Because when the press is threatened to be gagged or prohibited, it is of the same effect when a person is ano, threatened with a subsequent punishment. No? As mentioned before, there may be no prior restraint, but the subsequent punishment for an utterance may be as threatening as a prior restraint. That's why the courts should be cautious in entertaining libel suits against personalities in the media, because the media plays a great part in the democratic way of life. According to the Supreme Court, in Elizalde versus Gutierrez, a prosecution for libel should not be allowed to continue where, after discounting the possibility that the words may not be really that libelous, there is likely to be a chilling effect, a patently inhibiting factor on the willingness of newspapermen to um, especially editors and publishers, to courageously perform their critical role in the society. The chilling effect is akin to being gagged already, kasi not, they become scared to express their opinions. They become scared to express what they discover because of possibilities of lawsuits from public officers. This is a matter, by the way, libel is no longer a matter exclusive to publics or up to newspapermen or to broadcasters, because right now all of us has the access to um, alternative mass media in the form of social media. No? But primarily, this jurisprudence appears really to protect the press, mainstream media, foremost, um, legitimate media, from being discouraged to speak of the truth for the fear of criminal prosecution. Okay. Public servants are given less protection under the law when it comes to libel. In your criminal law, you will notice that in libel, there is a presumption of malice. No, when there is that general presumption of innocence, there is presumption of malice in libel for libelous statements. But the presumption of malice must be reconsidered when who are subject of the libel, the supposed libel loose remark, are public officers. Why? Because unlike private citizens, public officers have the greater access to media. They can refute and disprove claims against them, no matter how libelous. That's why their access to media, especially known politicians, allow them to better explain themselves, unlike private citizens. That's why they have lesser protection. No? That's why they are open to public criticism on media. No? Public officers also, when they enter into public office, especially those elected, understand fully well that when they get into office, that their function is public trust, and the public has interest on them or their functions. That's why when you are a public servant, you expect criticism. So that's something you expect. And the private citizen does not expect criticism of his private conduct. Yun ang pinagkaiba. Okay. So, the case of Borjal versus Court of Appeals has decided that it is not essential that the victim of libel be named. He can simply be identifiable. So if you are libeled or defamed, you don't need to be named. You can have a legitimate cause against the uh, person defaming you. You can have a cause against him despite you not being named, if you are zeroed in by the way his expression or defamatory statement targets you. If you are too specifically identified by your personal circumstances, even if you are not named, you could be subject of libel. So, hindi kailangan pinapangalanan yung biktima ng libel, by the way. This case of Borjal versus Court of Appeals. In this case of um, Vasquez versus Court of Appeals, on the matter of publication, private conversation does not give rise to libel. Maybe something else. It is only, or a private correspondence. It is only when the matter is publicized that our reputation is threatened between private individuals, or between a private in a private talk or correspondence between two individuals. There is no libel because there is no person to listen in or read the publication, the write up. But when it is published, a third person already gets to see or hear allegations against you, and your reputation is at stake. That gives rise to threats to your name. That's why in libel it is essential that there be publication. No, so publication is essential. According to the Supreme Court, a man's reputation is the estimate in which others hold him in, not the good opinion which he has on himself. So other parties hearing or knowing of a commentary or an opinion by another is publication. There is again that access of everyone to mass media because of social media. That's why we have the Cybercrime Prevention Act of 2012, RA 10175. It considers libel as well. It considers as unlawful the use of the internet, no, or a computer system, no, when you libel another, no. In fact, the penalty is heightened when the means of broadcast is social media or the internet. You are penalized 1 degree higher from that which is found in the revised penal code. In the statistics given to you in the previous video, we understand that almost all of us are into social media. Almost all of us are susceptible of committing libel. But you cannot be considered to be an offender here if you simply like or press a like icon to a libelous uh, post. Nor are you liable if you just share a libelous post. You may be considered guilty of libel if you add a commentary when you share a post, or if you comment um, another statement to the original post that is also equally libelous. Commenting alone on a libelous post is not libel, but when your comment is libelous, it is another crime where you are a principal of, separate from the original post. Freedom of expression and the right to privacy. This has got something to do with the use of uh, film, the film industry, no siya. Ito na discussion. This case of AR Productions versus Kapulong, this has to do with a film that eventually was released in the cinemas as entitled A Dangerous Life. Its working title was The 4-Day Revolution, which depicted the EDSA revolution and what happened um, to the players, no? Cory, Doy, Speaker Mitra, Ramos, and Rile, the legend, um, and everybody else, no? The persons known already in history as having played an important role in the People Power Revolution. Um, if you view this film, at the initial point, it was filmed in the Philippines, but midway, you find that the Filipinos now look like Indians or some other race, because Ayer was forced to transfer filming the movie in India, I think, because of because of this suit. Um, According to the Supreme Court here, there is no threat to privacy in the filming of the the story behind the EDSA revolution, because the EDSA revolution has become part of public domain, being part of history. What the Supreme Court only cautions is that the producers do not include in the film private respondents' personal lives, no? Sila Enrile, sila Ramos, hindi kasama yung kanilang personal lives. Only depict in the movie, which was actually with a fictional character, yung main actor there, a media personality. Um, but others, sila Cory, sila Mitra, sila Ramos, sila Enrile, Cardinal Sin, they could be depicted insofar as the public knows of their participation in EDSA revolution, not their private lives. On the matter of administration of justice, there is also a restriction to your freedom of expression. This is what we call the sub judice rule. Under the sub judice rule, um, there is a restriction as to comments and disclosures pertaining to the judicial proceeding in order to avoid prejudging the issue influencing the court or obstructing the administration of justice. This may render one liable for indirect contempt. Special caution to lawyers under the rules of court for judicial or um, legal ethics that if you comment on the merits of the case or make intemperate and unreasonable comments, these are on a matter of a pending case or proceeding, you may be considered as in contempt, no? Because of the violation of this sub judice rule. Yung sinasabing merits of the case includes the following: the credibility of the witnesses, character of the accused, soundness of the alibis offered, etc. Okay, in the list on your screen. On the matter of intemperate and unreasonable comments, your comments must not be intemperate and it must not unduly impair the dignity of the court. Hindi mo pwede paulawan ang korte. Okay? So, there are cases, Lejano versus People says that unwarranted attacks on the dignity of the courts cannot be disguised as free speech, where the exercise of such rights cannot be used to impair the independence and efficiency of courts or public respect therefore and confidence therein. Imagine the public having no trust in the court or with an impaired trust in the court. What would happen to our judicial system, which which all are reliant on in the attainment of the ends of their causes? No, people might resort to settling cases in alternative ways. No? There's this interesting matter involving the UP Law faculty when they released an official manifestation or statement with strong words, and as they also hurled accusations against the Supreme Court. These are prominent faculty members of the UP College of Law. According to the Supreme Court, kasi this pertains to their commentary or manifestation with how the Supreme Court, through the ponencia of a case in Binuya, the Binuya case, Justice Del Castillo, it's a case on the liability of the Japanese government for atrocities and sexual abuses against the comfort women during the Second World War. Apparently, if you read the case, there are the main case and the plagiarism case. There appears portions of the decision which were lifted from various text without the necessary attribution or footnoting of the sources. So plagiarism. But the Supreme Court, as as it decided in this case, um, took notice also of the comments of the UP faculty. As educators, we, as especially in the legal profession, people believe us. That's why whatever we say, especially on media, is it carries a great weight. So, according to the Supreme Court, their actions, the faculty of UP, the law faculty of UP, their actions run contrary to their obligation as law professors and officers of the court to be first to uphold the dignity and authority of this court, which they owe fidelity according to their oath. You read your oath, okay? Students, they have taken they have taken as attorneys, and not to promote distrust and in the administration of justice. On the matter of public service and freedom of expression, this is something that you have to remember, that while there is freedom of expression, no officer or employee in the civil service shall engage directly or indirectly in any electioneering or partisan political activity. So during elections, especially, you are not supposed to post on social media, for example, partisan political matters. You are not supposed to campaign as public servants. As public servants, you should remain neutral or apolitical. This is a constitutional um, restraint, no? Something that you cannot negotiate with. So there is no freedom of expression relating to partisan political activities for public servants. Um, it's different if you are an elected official. If you are an elected official, according to the Supreme Court, like the mayor, president, congressman, no, you can, during elections, even after you have filed your certificate of candidacy, still make or participate in partisan political activities or make partisan commentaries, because the very nature that you are of your being in office, being elected, is that you are political or partisan. Unlike those who are appointed are beholden to the appointing authority. There is no party affiliation required, no? There is no electorate that you answer to. So, ito din namang appointive officials, when they file their certificates of candidacy, if you're appointed, you have to resign from your public office so that you can participate in the campaign, no? So, upon filing of your certificate of candidacy, you have to surrender your public service, because you cannot campaign as an appointed official. Unlike elected officials, you cannot be considered as resigned if you file your certificate of candidacy, because of the nature of your function. You are elected and partisan in the first place. Second, you owe fidelity and service to your electorate. You have to finish your term, and your term is defined by law. For the members of the court are reminded of their obligation, the judges, no? The court often reminded judges to always conduct themselves irreproachably and in a manner exemplifying integrity and honesty and uprightness, not only in the discharge of their official duties, but also in their personal lives. In other words, their conduct must be guided by strict propriety and decorum, and at all times in order to merit and maintain the public's respect for and trust in the judiciary. So as members of the court, you're expected a higher ano um uh, there's a higher expectation um to maintain your integrity and your decorum, no? Higher restraint for you. This case, I think, of a judge in La Union, where his post on private were not too discreet. I think he was showing his abs or some parts of his body. The Supreme Court reminded the judge and um, reprimanded the judge to calling out calling out also his posts. So that's why the lives of judges are too restricted. No? Okay, let's go to this O'Brien test, content neutral restrictions now. Kanina it's content based. Now it's content neutral. For content neutral restrictions, um, there's this case, US versus O'Brien, that test has been applied in the Philippines, that for a government policy to restrict expression, um, it must pass through this O'Brien test. Ano itong content neutral restriction, by the way? If you recall from the previous lectures, you remember that this content neutral restrictions only refer to the time, place, the means of expression. While content-based restriction refer to substance. Ito is only on the circumstances, the means of expression. No? So, sabi ng O'Brien test, a government regulation is sufficient as a content-neutral restriction if it is within its constitutional power, it furthers an important or substantial government interest. The government interest is unrelated to the suppression of free expression. The incidental restriction of speech and press is no greater than what is essential. So in ethics, in moral philosophy, we call this the principle of double effect, where the evil is only a consequence which is unintended, which where the evil is proportionate to the good intended. The evil is an unintentional result. Okay, so similar to that, the free expression must be coincidental. It must not be the means, but an end itself. It is not a means, because if suppressing expression is a means, it is unconstitutional. It can be a result, but it cannot be the tool. Okay. Also, there must be proportionality, because you are restricting free speech. There must be a good reason for the restriction. No. Case in point is this case of Blue Umpar Adyong versus Comelec. Remember this case from previous lectures, the prohibition of Comelec on the use of stickers and decals for mobile places or vehicles. According to the Supreme Court, that's using free expression, restriction to free expression, prohibition of putting stickers. That's free expression. That is now the means and not the consequence. Um, it stifles upon free expression in the first place. Second, if the intention of COMELEC is to flatten or make fair or equalize the electoral process so that all candidates can be on equal footing, it can implement other laws but not prohibit free expression. Okay. And besides, I think free expression in during elections, free expression and robust discourse is always encouraged. This case of ABS-CBN versus COMELEC refers to the case where ABS-CBN was called out because of its exit polls. An exit poll is a mechanism where members of a survey institution or a media like ABS-CBN stays outside the polling places and interviews people who have already voted, who they voted for. Because of the exit interviews after voting, by the time election has been over, the media can already begin making their own tentative count from the exit polls. That's why ito yung tinatawag na tentative results, no, from the exit polls. It was more popular before when elections was manual. Now it's already automated. Mabilis ang result ng elections. Dati nung manual pa ang elections, napaka-popular nito because the results come in within the day of the elections. Mabilis. They just consolidate the results of the exit polls all over the Philippines. This case, you remember in your discussion of judicial review, this could have already been mooted out because the time the decision was made, elections has already been over. But according to the Supreme Court, decided anyway, using the third function of judicial review, which is symbolic, to educate the bench and the bar. According to the Supreme Court, even though the government's purpose are legitimate and substantial, they cannot be pursued by means that broadly stifle on the fundamental personal liberties, where the end can be narrowly achieved. Here, the suppression of free expression, which is the broadcast of exit polls, is a means and not an end. Okay? So remember, the restriction must be an end, not as a means directly. It should be unavoidable. Also, um, this case also highlighted that there was in any way no showing that the conduct of exit polls disturbed the electoral process. The same with social weather stations versus COMELEC, where there was this prohibition for the social weather stations to make public the results of their survey. Well, the intention here actually is the election exit polls, which would cause trending ba? because the survey says a candidate will win, there might be a mind setting as to the who will be voted for because of the prior survey. But this also stifles the prohibition of the publication of election surveys, also stifles freedom of expression. Okay, content neutral and national security. On Article 120, as to the matter of correspondence with an enemy country, the first two um, elements um, are content neutral actually. Correspondence is prohibited by government, it's a prohibition, and correspondence be carried by ciphers or conventional signs. Those are content neutral. The third one already is content based. Okay. Partisan political activity, ano ito? Okay. This is on the selling of ano ad space. You also read this case of Osimenia, giving or selling of free ad space, um, which was regulated by the Supreme Court. No, what is regulated here is the selling, but it does not prohibiting. It's only regulated. Uh, Content neutral restriction and freedom of assembly. The law in point is BP 880 or the Public Assembly Act of 1985. This was made law during the time of Marcos. No, this prohibited. This not prohibited, but this gave the public leeway for public assemblies. What is a public assembly? It means any rally, demonstration, march, parade, procession, or any other form of mass concerted action held in a public place for the purpose of presenting a lawful cause or expressing an opinion to the general public on any particular issue or protesting or influencing any state of affairs, whether political, economic, or social, or petitioning government for redress of grievances. The law regulates the use of public spaces and roads for rallies. Um, this excludes processions, rallies, parades, demonstrations, public meetings, and assemblies for religious purposes. This is covered by ordinance. It is also not including, does not include the law, BP 880 does not include um, pickets in the strike area. No, this is covered by the Labor Code of the Philippines. According to the law, permit is required when you want to have a public assembly. The exemption are as follows. It's the public assembly is made on a Freedom Park. When you do rallies or assemble in a Freedom Park, no permit is required. I'm talking about Freedom Park, not People's Park. The Freedom Park is a venue where you can hold rallies, even flash mob rallies, without any permit. Okay? You don't also need a permit if you conduct rallies in a private property. You only need to seek the permission of a private property owner. You also do not need a permit if you want to conduct rallies in any government-owned or operated educational institution, like UP. What if you want to conduct a rally inside the Ateneo University? It's a private property. No permit outside, no permit is required from the LGU, but you only need the permission of the university. But for public schools, you can't do that. No permit required. So according to the law, you apply for a permit if you want to conduct public meetings or public assemblies. The application should be in writing, include the names of the organizers or the leaders, purpose, the what, where, when, how, okay? You will conduct your rallies. You also have a list there in your application of the duty and responsibilities of the applicant. No? It's to remind them of the restrictions. No? You apply for it in the office of the city mayor or of the municipality. Huh? jurisdiction 5 days before the intended assembly. Upon tender, upon the receipt of the application, the mayor shall cause it to be posted. Now, the mayor must issue the permit except if the issuing of the permit has been denied because of a clear and convincing evidence that a public assembly will create a clear and present danger of a public order, public safety, public convenience, public morals, or health. Yun siya. Those are, that's the only reason why the mayor can deny the application. Okay? For rallies of longer durations or for massive rallies, the permit can allow only rallies at specific identified areas. Because while you have the right to rally, all other people have the right to go live their life normally within the day. So your rally must not duly impede traffic or commerce and daily activities of others who might not want to join. Okay, so it can be regulated but not prohibited here. No? In this case of Bayan versus Ermita, uh, saying that BP 880 is not an absolute ban on public assemblies, but a restriction that simply regulates the time, the place, and manner of assemblies, content neutral restriction. What if the mayor denies does not receive your application? You tender it. If it's refused, you post it in the conspicuous place in the municipal building. Okay? That's considered as applying for it already. Policemen are not supposed to interfere. They should stay 100 meters away from the area of activity and only for the purpose of maintaining public health and order. They are not allowed to have infiltrators there also. 100-meter distance. That's the radius of 100 meters. We continue with Administrative Matter 98702 SC in 1998 on the next video or the next lecture. Thank you.